Oversight Board. Thank you very much. Um, and so I will call the roll to determine quorum. Janice Mensa, Vice Chair.
Present.
Michael Milton. James Darm. Hillary Stuckey. Pam Walker.
Present.
Thomas Lawson.
Present.
Ornitha Lewis Walls.
Present.
All right, we do have 5. We do have a quorum. We're hoping that the others are able to get on. We need a motion to approve the minutes from August the 28th. Can we get a motion to approve?
Motion to approve.
And
Been
I'll
moved by
second.
Tom, moved by Tom, seconded by Pam. All in favor?
Aye.
Thank you.
Aye.
All those opposed, motion carries. So the minutes are approved. My report is hopefully it's going to be real brief. I'm glad to see that Alderperson Aldridge is on, because I may be calling on him just to give us an update on Board Bill 93. But that was one of the first things I wanted to share with you, is that Alderman Aldridge has presented and read Board Bill number 93. It was introduced by Alderman Aldridge the 15th of September, which was my birthday, by the way. Thank you for that birthday gift, Alderperson.
Happy birthday.
Thank you very much. I'm 39 again. The summary, I'll leave that. I'm going to leave that to the Alderman, if he would be so kind to share the summary and the timetable that he's operating under. I want to give him some time during the chairperson's report to do that. Alderperson, are you able to do that at this time?
I wasn't prepared, but absolutely, since it was your
I know
birthday.
you're always prepared. Stop that. Stop. Don't do that. Don't do that. That's way too modest.
I know.
If you would, just a summary, if you would, Alderperson, and maybe just an idea of what time frame you're operating under, and what we should look for as far as next steps.
Yeah. Well, first and foremost, thank you, Mr. Chair, for giving me the space. Happy belated birthday. Thank you to all the members of the DFOB board for all the hard work that you guys continue to do to try to seek oversight. So since coming in front of the Public Safety Committee and reaching out to all the people, I will say I've made it clear, and several other Alder people, including the president, made it clear that we hear the concerns and we wanted to address them. So this is a start of trying to do that. While legislation takes some time, hopefully we can get some action before that. But file Board Bill 93 that does several things, from some meetings that I've had with DFOB members, as far as trying to get some clarity around training and orientation and make that more clear. Working to try to figure out how we could give DFOB legal counsel, and assuring that nothing will be able to stall y'all work to be able to actually get oversight. So the time frame of that, the board bill was just introduced last Friday. My goal is to, by the beginning of next month, if not the end of this month, start having committee hearings on it, which one of those committee hearings would be reaching out to the DFOB board members to come in front of the public safety to answer concerns or comments, either to the legislation or just in general as this piece of legislation is crafted. Want to ensure that everybody's voice at this oversight board is being heard. So ideally, in a perfect world, I would love to have this final piece of this legislation wrapped up at the end of October. In a non-perfect world, probably be the beginning of November, but moving very swiftly. We're trying to have the right conversations to make sure it's legally standing, as well as ensuring that it works with the Public Safety Committee. As the Board of Aldermen is actually being renovated right now, we don't want to have a Zoom. We want to make sure people can come in person. So In the next few weeks, I'll be reaching out to the chair to request DFOB to come in front of public safety to have input on the board bill and just any other inputs that could make this board bill stronger so that y'all can do y'all work.
Thank you, Alderperson. I just want to give the board members an opportunity. I'm going to ask board members, for the sake of time, if you have any questions for the Alderperson, not necessarily commentary, but so we can move on. But do you have any questions, board members, for the Alderperson? Anyone? Thank you so much, Alderperson. We do want to, again, on behalf of the board, thank you very much. You took up the gauntlet, not on behalf of the board, because I think it's a misnomer for people to think that what you're doing is for the DFOB. What you're doing is for the detainees and for the correctional officers and for the staff. And so your work has everything to do with transparency and accountability. And it's not just you going to bat for the DFOB. And so we want to thank you so much for that. And someone asked me along the way, Alderperson, about our confidence in you. I think I can speak on behalf of the board. We have the utmost confidence in you and in your commitment to seek justice and accountability and transparency. And so thank you very much for all that you're doing.
No problem. Thank you for the time and look forward to working with the board members. I'll say before was elected, was out there in the streets like many of us. Ferguson has a big, it's personal to me. So, you know, stuff like this legislation oversight is, I think, just important for our city to have those check and balances. So I just appreciate y'all letting me come in front of you all and look forward to working with the members to make this possible.
Thank you so much, Alderperson. I want to also now give some of my time. I think, Pam, the secretary of the board, there was a question raised, just a general question, as related to the board's authority based upon the ordinance dealing with operations. And I think, Pam, you had something you wanted to read into the record.
Yes, I do. Give me 1 second to find it out of all of our emails.
When Pam's glasses go on, she means
Watch it. Hey, you know you're right, too.
Yeah, it means I could see for a second.
Well, that's important.
Yeah, the issue is we keep reading in the press that different people in the administration are saying that under the current ordinance, we have no authority over operations. And I just want the official record to be clear that the ordinance in several instances gives us very clear authority over operations. In 71430, as pertains to our authority to investigate, it says in a couple of places that we may make findings and recommendations based thereon, including recommendations for disciplinary action. I thought that was important because of our vote to discipline the commissioner. And then in another place it says information relating to the development, implementation, and enforcement of division policies and procedures. Number 4 says information relating to division directives, policies, and procedures, including those that concern detention facility operations and maintenance, conditions of detention, and division employees. Number 5 says information relating to the division's administrative detention facility operations and maintenance activities. And number 8 says any division or city directives or policies, including without limitation, those related to detention facility operations, administration, division employees, detention facility conditions and maintenance, and detainees. The law is very clear that we have access and can make recommendations in all of those areas. And I wish in all sincerity, that people in the administration would read the ordinance before they make public statements that are not accurate.
Thank you. Thank you very much, Secretary Pam Walker. We've been trying to be clear to the board has been trying to be clear. It seems as though we've become the target, and it seems as though there's a PR campaign to vilify us. And so we continue to be committed to following the ordinance. In light of that, just want to also revisit the letter that we received from the mayor. In it, the mayor made a quote regarding training. And I stated at the last meeting that I was a bit concerned about that quote because I didn't understand where that quote came from, and it was under training. And according to the mayor's letter, under training, it said, additionally, the circuit court that reviewed the DFOB found, quote, that portions of the ordinance related to investigation, information sharing, and discipline will not become effective until appropriate rules and procedures are drafted as stated in the ordinance. And then it says, in other words, the DOC, which the ordinance sets up, shall not be activated until these further rules, procedures, and protocols are created and presumably determined to be complied with applicable law. I did reach out to the circuit court because I wanted to be clear where that quote came from. And I did receive a communication from Joe Courier, the Chief Communications Officer of the 22nd Judicial Court. He did send me, he attached the file, file 090922, ordering St. Louis Police Officers Association v. the City of St. Louis. He indicated there are two subsequent orders in that case, as well as on 10/11/22 and 3/24/23. The March order ended the preliminary injunction for purposes of jail oversight. I've attached those two orders below. What I wanted to find out, the rulings that that were quoted in the mayor's letter. It was my understanding and opinion that the Oversight Committee, the DFOB, had been detached from the lawsuit so that we could continue our work, and that the lawsuit still dealt with the COB. It was my understanding, and I'm still trying to get clarification, if the ruling that the mayor is quoting is the ruling that pertained to the COB and not the DFOB. And so I just wanted to say to the board, we are still researching that. We do have that. I have asked a lawyer to pro bono. Can't hire anybody, but we've asked for some advice to look through that particular ruling. Those are the two rulings, file number 101122 and file number 032423. Each of these filings are labeled by date. And the review that I'm looking for is having the rulings reviewed, because it's the opinion of the chair that these rulings were specific to the COB and not the DFOB. So when we continue to talk about training, there continues to be a lack of clarity, particularly in the ruling that the mayor stated, that this final ruling pertained to COB and not DFOB, and we are still trying to work out that clarification. And so I just wanted the board to know, because that was one of those things that the board asked me to look into at the special meeting. So I just wanted to let you know that we are looking into that, and I will send a copy of the rulings to all of the board members so that you can review it yourself. And then finally, before we, and we're making good time, one of the other things that I think we needed to get clarity on, Vice Chair Mensa made a motion, which was seconded by Thomas Lawson, that we begin an investigation into the conditions leading up to the death of Carlton Bernard and Terrence Smith. We indicated very clearly that we know right now that we don't do criminal investigations, but we wanted, and so we wanted to be more specific as to what that investigation should look like, the scope and the time frame. And so we are recommending to the staff, whatever staff is going to be assigned to that, is that review begin as of January 1. We want them to go back to January 1, 2023. That is when we're asking that scope to begin, leading up to the death of Terrence Smith, the late Terrence Smith. And so, because we understand that his incarceration was somewhere in and around that first or second week in January. So we want that investigation to look at the conditions. We want that investigation to include speaking to detainees that were incarcerated as of that period, and who are still incarcerated as of January 1, and any detainees that have been released between the period January 1 and the death of Terrence Smith. That testimony or information from detainees and or family members, correctional officers who were employed during that time as of January 1, or who have left employment after January 1. Any staff, administrative staff, who are currently employed as of January 1, or who have left between the time of January 1 and the passing of Terrence Smith. We are asking that investigation include, but not be limited to, speaking to vendors, specifically food service vendors, medical vendors, and maintenance vendors. To include those, but not be limited to those. Food service vendors, medical vendors, and maintenance vendors. Once again, the idea is to investigate the conditions leading up to the death of Terrence Smith. When we talk about speaking to those vendors, we're also talking about any documentation as relates to services provided by those vendors, to include financial statements, verification as to contracts, what services were to be provided by food vendors, medical vendors, or maintenance vendors by way of contract, what those contracts stated, and any lapse on our part in fulfilling our, when I say ours, the city of St. Louis, in fulfilling its responsibility to the contract, or to the vendors not fulfilling their responsibility as related to the contract. I'm trying to see if there was anything else that should be included. Once again, as I indicated, the things that we're asking our investigators to look at we're saying include that, but not limit your investigation to things that we're interested in. We're interested as a board to see if policies and procedures were followed. We're interested to see if protocol was followed. Uh, and I think that might have covered it. I'm going to ask board members if I missed anything as related to what our expectation of that investigation should look like. And I'm once again, I'm going to ask board members if there's something I missed, if there's something that should be included in that investigation. I know that our staff understand the process and procedures of doing an investigation, but I just wanted us to be clear what the board members were looking at. So I'm going to go down the list. If I missed anything, if there's anything to be added, Vice Chair, was there anything that?
Yeah. I know staff is already aware of this, but just for the sake of saying it in the meeting, it wasn't on the list, so I'm not sure if this was said, but that the investigation would include interviewing people who are detained, corrections and medical staff that were on duty during either Carlton Bernard or Terrence Smith's stay.
Okay, thank you very much. And I'm glad you said it because we do want it to be specific as well. We know Mike's not on. Secretary Walker.
Yeah, just for clarity for people who are from the public or are not on the board, in Director Coyle's letter, he said that the staff was fully trained and could begin investigations, but that they could not share it with us until what has magically turned into 40 hours of training are completed. That was the first I heard, 40 hours. I'm sure next week it will be 60. But there's a lot of lack of clarity around that. Does it mean we all have to be trained? Are those of us who finish 40 hours, can we get access to it? How do we do that in a board meeting? What can be open for the public and what can be closed? But I want people listening to rest assured that we will get access to that investigation, and we will be making recommendations for changes.
Thank you. James Darm, Board Member Darm.
Yes, sir.
Anything that should be included that was not included? Did we miss anything?
I don't believe so.
Okay, thank you. Board Member Stuckey.
I have no further comments. I'm here.
Thank you.
Thank you.
Board Member Lawson.
I think we're good.
Board Member Lewis Walls.
I think we're good also.
Okay, thank you very much. We just wanted to make sure that the staff heard from us as to what it is that we are going to be looking for. And of course, it is not limited. The staff investigation obviously is not limited to concerns or that we have or things that, because once again, they are the expert investigators. And so we're going to rely on them to do due diligence to this. And so the last thing that's really all I believe that we had.
Reverend Gray?
Yes.
I did have my hand up.
Oh, I'm sorry, I didn't see it.
I'm trying to figure out how to inject this without invoking a legal conversation. I wasn't sure if I had communicated to you or the board that the office did receive a non-interference letter from Chief Tracy regarding this matter. And so even though I hear what you're saying in terms of limiting the scope to conditions, what I'm not sure of is whether or not that scope still might be determined as an interference. And since we have accepted the letter, we have noted the letter, I have paid attention to the directives from the public safety director. And I think, speaking on behalf of the staff, if we could get some clarification as to whether or not there's a distinction there from a legal standpoint, it might be easier for us to gain access and conduct the investigation.
All right. If you're referring to the letter of September the 11th, the director of public safety states that the DFOB staff and investigators are authorized to commence investigations within the detention facility upon the conclusion of their training, which has taken place. And so the staff has, right. So the staff has completed their training. The director of public safety has stated in his communication of September the 11th that DFOB staff are authorized to commence their investigation. He does state in the next two paragraphs, investigators and staff must maintain strict confidentiality throughout the investigation process. Information to ongoing investigations should not be shared with unauthorized individuals. Investigators and staff shall not share their findings to the DFOB board members until the board members have completed the orientation training. So we concur. I'm
referencing, I'm sorry, did you receive a copy of a September 7th letter from the Director of Public Safety?
No. The only two letters that I've received are September the 11th, and so I have not received anything as far as the 7th. But I would think, Commissioner, that whatever you're saying the police chief. So do you mean Police Chief Tracy?
No, I don't have that letter. I did receive one subsequent to the board's vote to conducting it. No, I received a letter from the Department of Public Safety, the Public Safety Commissioner. Right. So, and it's regarding directives for COB and DFOB staff and investigators. And in that letter, there's reference made to the non-interference with ongoing criminal investigations and exclusion of matters involving litigation. So we have been directed to take that into, and I'm only suggesting, Reverend Gray, at this point, because I don't mean to come off insubordinate. To me, it just raises the issue. And I'm putting it before the board.
Understood. I mean, yeah. And Commissioner, I never would think that you'd be insubordinate to anyone. You're a person of integrity,
I've been told.
Integrity and high character. I'm just simply stating that I have not seen the communication of September the 7th. And that's number one.
Okay. Well, I looked at it more closely, and it wasn't. Initially I thought it was for DFOB members, but it is specifically directed to staff and investigators.
Okay, and so what I'm stating is, I'm taking it as fact that letter exists, but I'm also taking as fact the September 11th letter, which is dated after September 7th.
Yes,
and
sir.
In the September 11th letter, the director clearly states that the staff are authorized to commence investigations. He does state that the staff, in his words, exercise discretion and refrain from impeding any ongoing criminal investigation. Now, we're calling for an investigation into the conditions of a jail. We're not asking for any criminal investigation, nor the criminal investigation that I understand that the public safety or the police and the circuit attorney are engaged in is the alleged hostage situation. not the death of Mr. Bernard, nor the death of Terrence Smith. I don't know of any investigation, criminal or otherwise, that anyone has instituted on behalf of the death of Mr. Bernard or Mr. Smith. I don't know of any investigation. The only investigation that I know of and have been privy to is a criminal investigation into the alleged hostage situation. So maybe we need some clarification from the director. What investigation is he referring to? Because his office is being too vague. And this is not to you, Commissioner. This is that on September the 11th, it is clear that the director is is agreeing that the staff can now move forward. But it can't give us information until we receive our training. I'm clear on that. I don't agree with it, but I'm clear on it. It doesn't, this letter does not preclude, nor restrict, nor prohibit the staff from doing its job.
It does address non-interference, and that would be my only concern at this point, that it possibly puts the staff in a precarious situation unless and until we receive some clarification as to whether or not the limited scope that the board has directed relative to the conditions during the time frame, whether or not that is interference or could be interference.
Well,
I'm just wanting that clarification for purposes.
I understand. So what I'm stating then, commissioners, this is what I think the board is asking. Based upon what we have requested as far as an investigation is concerned, I think that once that is written up and stated that the board has directed the staff to begin an investigation into the conditions of the jail from January 1 to the time that Mr. Smith died. And these are the areas that the board has asked the staff to review. Once that is put in writing, and I suspect that we then would submit that as part of our collaboration, because the ordinance says that we should collaborate, then that communication then can be sent to the director of public safety and the commissioner of corrections and the city attorney, to those three people, in a spirit of collaboration, saying that we are calling upon the investigation to do these things. And based in a spirit of collaboration, we're letting you know that this is what we're going to do. And then let them respond to say, oh, excuse me, we think that you're interfering. And then let them respond. But would that be?
Thank you. Yes, sir.
There you go.
That helps my comfort level.
And you know what? I live to make sure I'm doing things, to make sure that you know, Commissioner, that we are paying attention. And you're absolutely right. We've got to make sure that what we're doing as a board is done proper and in order. And that's all we want to do. So thank you for helping me get to that point.
Thank you.
Chair Gray.
Yes.
I don't think it's interference for us to expect the chief of police or the director of public safety to come before us in a closed meeting and explain to us exactly what cases are being criminally investigated. Because all we've heard was these are natural causes. They could have died at home. If there's a criminal investigation going on in the two deaths that we're asking about, not only do we need to know that, the public needs to know that. And I don't see that as interference. That's not how I would define interference.
Thank you very much.
I think that request should be made as well.
All right, we'll make a note of that the chair will reach out to both the director of public safety and ask him to meet our board to discuss any pending in a closed session, to discuss any pending criminal charges as it relates to the detention facility. So I've got that on my to-do list. I think we did say we want to begin training around the 5:45 mark, and so we're almost there. Is there any new business to come before the board? Anything that is urgent that we need to deal with before we move on?
Yes, Chair, I have something.
Yeah.
So one thing is that this is a motion, but I'm just gonna throw it out there first. I'm interested, while they're figuring out what interference is with the Carlton Bernard and Terrence Smith investigations. If we launch an investigation into one of these other cases that is there in the facility around the same time as Terrence Smith was and Carlton Bernard was, and we investigate the conditions around their case, how could that possibly be interference? Is what I.
Yeah. And I think, Vice Chair, that's what we want to ask them. I think once we develop our scope of what the investigation is going to look like, and share that with the Director of Public Safety, then as Board Person Walker said, I think that they'll have to be obligated to then say to us, if they think that our investigation would impede, they would have to tell us where. And that's, I think, what Secretary Walker stated is absolutely right. And I think that's where Commissioner Barner is to make sure that we're not doing anything, that we
If I may
develop the
add,
scope.
though, any of the cases where we do not have a letter or notice of potential interference, we're preparing to investigate those cases now.
Right.
We are prioritizing a listing of cases. I think they've even completed the investigative plans for all of the cases that have occurred since the board was created. There were some of the deaths that happened before the ordinance was passed. And so,
Right.
so we're probably don't have jurisdiction to do anything with those. But certainly that is exactly what we're doing, Vice Chair Janice. We are getting ready based upon the declaration that we are now prepared to investigate. We're in the process of doing that, and we will be making arrangements with the Commissioner of Corrections to begin that, because we are required to give her notice.
Okay.
Right.
Well,
Yeah.
I have a motion to make. I'll make it quick. So I understand what directives you have been given, Ruby, about not sharing information with us, investigation information with us. With that in mind, I move to that we have a space on our agenda once a month to receive a report on any ongoing investigations that the staff has undertaken.
I think we can probably do that as long as we're not sharing personally identifiable information.
Right. It could be.
We have numbers and types and categories. We can do that.
Okay.
So we don't need a motion for that, Vice Chair. I think that if we request the staff to have that information available, then we can make that, we can just, as you indicated, have that on the agenda. We don't need a motion.
I would prefer it as a motion, just in case Coyle or whoever says we can't do it. I think it's still important that we have it as an item, and we can, then announce at that time that at this current moment, due to XYZ's email or directive, we're not allowed to share information with the board.
All right. I want to, is there a second to the motion?
Janice, could you restate it for me?
Yes, so the motion is to have a monthly agenda item where where the board receives an update from staff on any ongoing investigations. Period. That's the end of the motion. And that could be in public session with just the numbers, or it can be in closed session with other information. The motion's just to have that as a regular agenda item.
Yes, I will second that.
All right, it's been probably moved in second. The motion is to have on our monthly agenda report from staff as relates to pending pending status or status on pending complaints,
Investigations.
investigations.
Correct.
Okay. Any question on the motion? Any question? Remember, we on this, we need to make sure we show ourselves on camera. All in favor of the, excuse me, go down the list. Vice Chair Mensa,
In favor.
James Darm,
Aye.
Hillary Stuckey,
Yes.
Pam Walker,
Yes,
Thomas Lawson,
Aye.
Onetha Lewis Walls.
Yes.
Okay. Motion carries. Oh, excuse me. All opposed, seeing none, motion carries. Thank you. All right. Thank you, Vice Chair. Any other new business to come before the board before we move? Scheduling next meetings, I did send out a communication. I'm asking board members, we don't have many more of these training things to do, I don't think. I agree with Sister Ms. Walker. We said 40. I don't know where that magic number comes from, but anyway. So if we can agree next Monday that that we would begin, that we would have training again next Monday. If there is anything that we need to deal with as far as an agenda item, we'll look at that. But we want to give at least 2.5 hours next Monday for training. We've set a goal as a board to try to complete all of our training by the end of October. And so I just want to ask the board again next week, Monday, 5 to about 7:30. Our hope is to have at least 2 trainings in that. So if we can get at least 2 trainings, is anybody opposed to that? All right, seeing that there's no one opposed, then next week, Monday, that will be a training session. And we will communicate with the executive director of the Criminal Justice Coordinating Committee as it relates to the 16-hour training that has been proposed by the Commissioner of Corrections. And so that's that. Do we need a motion to adjourn? Do we go right just into training? Do we need a motion to adjourn our meeting? I'm asking the lawyer, Ms. Barbara, do we need a motion to adjourn this meeting and then go into training, or is the training part of the meeting?
It's on the open public agenda. There's no notice to close. So if
Okay.
you're not planning, just move
All
right
right.
along.
That means everybody gets to be trained with us. So at the end of this training, everybody on this training, you get to come on the board. I'm just joking, being facetious. Who is on that is responsible for training?
Chair, really quick.
Officer Perry.
Okay.
I saw him earlier, but I don't.
I do see Stephen Perry. I see the name is up there.
Okay.
Yes, Vice Chair. Now we're moving into training. Yes, Vice Chair.
Is this going to be recorded?
I think everything's recorded. Yeah. Yeah,
Okay.
because it's part of our meeting.
Okay.
Yes, the entire meeting, training included, is being recorded.
Excellent.
Okay, perfect. I'm going to be hopping off now, and I will watch this training later.
All right.
All
Thank
right.
you, Chair.
Have a
And
good-
we still have a quorum, so that's good. And so I'm going to turn it over to the trainer. I believe, is that Stephen Perry?
Yes, it is.
All right. Hey, how you doing? So
Good, how are you?
now have us, and let me sit back and get a cup of coffee, and it's all on you.
Good evening, everybody.
Hey, Mr. Perry, you want me to turn host over to you?
Sure. I have to share my screen, so if you don't mind.
All right, I'm great. Do it right now.
Okay. Good evening, everyone. I'll start first by kind of introducing myself. My name is Police Officer Stephen Perry. I am currently an instructor at the Police Academy, where I teach constitutional and Missouri statutory law. I've already provided some training for some members of the board a week or so ago. So if they're here, they're listening, they're gonna get double training. Okay. I've lived in St. Louis all of my life, born and raised, graduated from Sumner High School in 2007. I started with the agency back in 2010, June 28th to be exact. I graduated the academy January 7th of 2011. So I've been on the department for roughly 13 years. I've served most of my time in North City on patrol. And I officially came down to the academy in August of 2017. So today we're going to discuss some things, some very important things. This is content that I would typically teach to the Citizens Academy. I can't really give you content that I would teach to recruits because it's a lot. It would take days to teach you that. So this is just going to basically be a crash course of what you need to know in terms of constitutional and some aspects of statutory law as well. And we'll also have some discussion on prisoners' rights. So there's a section in recruit training for constitutional law called Prisoners, Privileges, and Rights, as it pertains to post objectives provided to us by the state of Missouri. It's a very small section, but it's important, obviously, because you guys investigate incidents, I guess, that take place with the Department of Corrections. So I thought that was something important to touch on as well. So we'll first start with the constitutional side and just kind of give you guys some insight on that. Let me share my screen really quick. So typically when I teach kind of fast sometimes when I kind of get going. So if at any moment you have a question, please stop me and ask whatever question. There is nothing outside the realm of what I can answer unless it's not within my scope to answer. I'll let you know if it is or isn't. I was told to only address things that I'm teaching and not to provide any amount of opinion on anything we discuss. So that's the safest way for me to be. So let's dive in, okay? Now, each time I teach recruits, I explain to them that this is not law school. I don't teach them how to be attorneys, but I give them the very foundation of what they need to know and understand as police in St. Louis. And that can be police in the region as well. So we'll dive in. We'll make it real simple. Again, if you have questions, just stop me and ask at any moment, okay? Can everybody see the screen? Outstanding. Outstanding. So first, we can start by talking about the Constitution, okay? So we all understand the Constitution and what it does for our country, okay? Is the first, well, not the first, but it's the oldest document that the U.S. government still acknowledges to this day, okay? So it did several things for us. First, it was created back in 1787, and it was ratified the following year, okay? Now, keep in mind, at this point in our country's history, we were still kind of getting to a place of understanding as a country, okay? We weren't fully established. We were pretty much settled on the eastern portion of the country. And again, things were kind of migrating west. But we had to first establish some body of government to govern a brand new country, okay? The most important thing that the United States Constitution does is to define basic rights of the citizens who live in this country, okay? It essentially tells us the do's and don'ts for the government, okay? No one likes big government at all, okay? And we all understand that. However, they do have certain rights. They can implement certain laws, but we have to govern that power, okay? Which is what the Constitution is designed to do. Also, any power that is not reserved by the United States government is reserved in each individual state, which essentially says that each state within our country maintains a certain level of sovereignty within this country. Okay, so they have their own constitution and they govern themselves within that particular state. So Missouri, we have our own constitution, California, Texas, New York, etc. Okay, we're not all governed the same. We all govern ourselves different. Okay, and that's very important for each individual state because we all have our set of individual ways of governing. Okay, so let's kind of dive in. We're only going to talk about the most important amendments that apply to law enforcement as we go through. Okay, we're going to start with the First Amendment. Somebody's in the waiting room. We admit them in. So let's start with the First Amendment. Okay. Now, there's 5 very important aspects to the First Amendment that we must understand. Now, this may have not have been a huge thing for police in this region when it comes to freedom of speech, which we'll talk about in a minute, until the tragic incident in 2014 in Ferguson. Okay. But it came to light, it exploded, right? So now it's important that we touch on this and we expound on what's important about the First Amendment so that police understand and the community we serve understands as well, okay? So the first important aspect of the First Amendment is the Establishment Clause, okay? The Establishment Clause essentially says that the United States government cannot establish a religion for the country, okay? So the President of the United States cannot take office and say, hey, listen, everybody in this country has to practice Christianity, okay? Absolutely not. Anybody in this country has the right to essentially exercise whatever they want in terms of religion. We cannot really establish that for the country, okay? The second would be the freedom of religion, okay? They can exercise whatever religion they choose to. We have freedom of speech, okay? So you can essentially say anything you want on any platform. Now, not all speech is allowed, okay? Hate speech, threatening speech, okay, is not allowed. Technically, in some aspects, it can be a crime. But for the most part, the vast majority of the things that we say are allowed legally, okay? We have the Citizenship Clause. I'm sorry. We have the freedom of speech. We just talked about that. We have the freedom of press, okay? So members of the media can respond to report things that they observe in any capacity that they want that is constitutionally protected, okay? And of course, we have the right to peacefully assemble and address and redress any issues that you may have, whether that be local government, state government, the federal government, it can be a local business, whatever the case may be, we have the right to address that, okay? So that is a right that we must maintain. Now, let's kind of ask ourselves some questions based on some things we just learned. What am I legally allowed to say? Just like I stated before, essentially anything if it's not threatening or hate speech, okay? We cannot go into a plane and shout bomb on a plane, right? We may incite a riot. That could be an issue. We cannot go into a movie theater, a crowded movie theater with a brand new movie playing and shout fire, okay? That may incite a riot. That can be illegal, okay? And very problematic for the safety of the people inside. On the flip side of that, we have people who go on platforms such as social media and they decide to speak their mind. Totally fine, okay? Absolutely fine. Unless it is speech that is threatening, okay? Is protesting okay? Absolutely, okay? Most aspects of training is allowed. I mean, most aspects of protesting is allowed based on the Constitution, okay? However, there are instances where protesting can become unlawful. So state statute says that if 6 or more people assemble in a particular place and they threaten to violate any state or federal laws by way of force or violence, it would then be deemed an unlawful assembly, okay? At that point, it becomes a crime. The goal is to prevent that from happening, okay? If they want to peacefully assemble and protest and say anything that they want, absolutely. We encourage it as law enforcement, okay? However, when it becomes violent, that can be problematic, not just for police, but even people there to just watch and observe. It can become violent for everybody, okay? And it can become a potentially dangerous situation. We don't want that to happen, okay? Now, if they take it a step further and they actually engage in this conduct that they threaten, okay, such as breaking windows, which is property damage, setting things on fire, which is arson, okay, then it becomes a riot. Very problematic, okay? Things start to escalate. So when it is announced, because there's protocols in place, when it is announced that, hey, listen, this is now deemed an unlawful assembly, everybody has to disperse. For those who refuse, can also be arrested for refusal to disperse, okay? But again, the goal is to prevent that and just to allow people to express themselves and just redress any grievance they may have, okay? Now, let's switch gears a little bit, and we're going to talk about the Second Amendment. I would imagine that somebody on this Zoom call exercises their right to keep and bear arms, okay? This has been a hot button topic in not just the country, but Missouri, okay? We all understand that living in Missouri is a little unique as it relates to our partners in Illinois, right? So the gun laws in Illinois, which is just across the river, are completely different than they are here in Missouri, okay? So we understand that Missouri allows certain gun rights to take place, okay, which we try to respect in terms of the Second Amendment. So let's dive into it so we understand how it works in not only this city, but this state, right? So am I allowed to own a firearm? Absolutely, okay? Most states would acknowledge this. Some states won't allow you to carry it, and some put certain things in place, certain licenses that you must acquire first before you own it. But here in Missouri, absolutely. Not only can you own it, but you can go in, you can buy it. The second you walk out of the door, you can put it in your waistband and you can carry it, okay? As long as you're 19 years or older, you've legally acquired it, you can carry that weapon without a permit, okay? My hope is that everybody understands how that law works here in Missouri. So prior to 2017, in order to conceal a handgun, you must first pass a class, okay, and be granted permission by the sheriff's department to possess a CCW, which is a concealed carry permit, which would then allow you to carry concealed handguns, okay? And thus would then allow you to openly carry, okay? Now that has been changed, and even without a concealed carry permit, you can lawfully, technically in Missouri, carry a concealed handgun, okay? Now, it says that in order to openly carry in Missouri, you must first acquire a concealed carry permit, which is kind of ironic. They still name it a concealed carry permit, but it allows you to openly carry, okay? Now, some residents still go out and take the time to take the class and get an actual permit. Some do, but you don't necessarily have to, okay? But in terms of owning one, yes, you can. So we just vaguely discussed Missouri gun laws, okay? It's a lot of controversy that surrounds it. We won't dive into it, okay? We'll stay away from that. But that just kind of gives you an idea as to how it works from a constitutional standpoint, okay? Now, let's get a little more specific as it pertains to police work and what we do every day, okay? So I explained to the recruits that the Fourth Amendment of the United States Constitution, which falls into the Bill of Rights, is by far the most important amendment for police, okay? And they asked the question, well, Officer Perry, why is that the most important amendment? It's the most important amendment because, one, it's the most litigated, okay? Most of the issues as it pertains to law enforcement, things that we encounter in terms of lawsuits, liability, etc., use of force, comes from the Fourth Amendment, okay? So let's discuss it. Unreasonable searches and seizures, right? Now, keep in mind, this only applies to government officials, law enforcement, local, state, federal, okay? It only applies to us, not civilians, only police, right? So what does it mean? What does unreasonable searches and seizures mean, Officer Perry? That means that the police, law enforcement, we are not legally allowed to, one, stop people when we want to, which is a seizure, okay? We cannot grab on people when we feel like it. That is a seizure, okay? We cannot use force when we choose to, unless legally justified, okay? And we cannot take property from people unless we can legally justify it, okay? All of those are considered seizures that fall under the reasonableness standard of the Fourth Amendment, okay? Any action that we take in terms of a seizure has to be reasonable. Doesn't say it's not allowed, even if the optics don't look well. The law specifically says as long as it's reasonable, it's allowed, it's not prohibited, okay? The flip side of that talks about searches. The police search people on a daily basis, okay? Very important that we understand what is and what isn't prohibited, okay? What does that mean, Officer Perry? That means that the police cannot search houses when they feel like it, homes, apartments, condos, okay? They cannot search vehicles that they stop whenever they feel like it. We also cannot search people whenever we feel like it, unless each realm of that is legally justified, okay? That rule is not absolute. There are exceptions to that rule, okay? We have a ton of exceptions. Case law supports those exceptions, okay? But police recruits, before they hit the street, they must understand those exceptions, and they are tested on it to make sure not only do they understand it, they can memorize it, but they can apply it practically, okay? Very important. The back end of the Fourth Amendment talks about search warrants. So we cannot acquire a search warrant from a judge or a magistrate within this state unless we can first establish probable cause by way of oath or affirmation, okay? So you have to take evidence that you have discovered, that you have put together, that you have conducted an investigation that leads you to believe that a crime is being committed at a particular place, and certain items and certain people must be seized, and that item is there at that moment. I need a search warrant to get it now, okay? That is the second half of the Fourth Amendment. So let's dive into some questions. Are the police allowed to search me? Sure, they are, if legally justified, okay? We talk about 3 types of citizen contacts: consensual stops, brief detentions, and custodial arrests. It is very, very crucial that police recruits understand what all 3 of those mean and how we can justify taking part in all 3 of those, okay? So let's discuss it. A consensual stop requires no justification at all, technically, okay? A policeman can simply have mere suspicion or a hunch that this person that they're interested in is involved in some criminal activity. Keep in mind that this does not justify the police to keep or hold that person there. That person is free to leave at any moment that they choose to. It also means that that person is not compelled to answer any questions or identify themselves to the police. They can simply go about their day, okay? The police have no justification to stop and detain that person. A step up from that will be a brief detention. It has several names, actually. Brief detention, investigative stop, stop and frisk, Terry stop. It has a ton of names, okay? But the police cannot, or they will not, or not justified in conducting those types of stops unless they first establish what is called reasonable suspicion, right? So you may say, well, Officer Berry, what is reasonable suspicion? What does that mean? That means that the police have established certain specific facts and articulable facts, which will lead that policeman to suspect that criminal activity is afoot and that this person may or may not be involved, okay? Now, keep in mind, I cannot just be vague when I say what you're doing is suspicious. Your behavior is suspicious. That is too vague, okay? You have to be specific. You cannot be vague in your description as to what you've observed as the police. Not only that, you have to take what you've observed and articulate it, which means explaining it in a police report as to what you observed, what you saw, based on your experience, your training, okay? As to why I suspected this person was involved in this specific crime. Let me give you an example. Let's say that you're working the late night shift, overnight, it's 2 a.m, and you get a call to, let's say, a Dollar General for a burglar alarm at 2 a.m, okay? So what is unique? First, let's talk about time and place, right? So I'm working nights, it's 2 a.m, and I get a burglar alarm at a Dollar General, which closes at about 9 o'clock at night. No one should be there, okay? It is closed. Okay, so I respond, I check the front door, everything looks fine. Everything checks out. Everything looks good. Okay, you just get a general alarm. Doesn't specify what door. So you respond to the back of the business because we want to ensure that the back is safe and hasn't been vandalized. And let's say as we approach the rear of the business, we see an individual walking away from the back door of the business. Okay, so a lot just happened. I'm working nights, 2 a.m. General burglar alarm at a business that is closed. No one should be there. When I arrive, this person is walking away from the back door of the business. They are the only person there, right? Well, based on all of those factors, all of those specific facts that I put together, which I can explain, I can articulate, I now suspect that this person may or may not have tried to break into this business. I can then, based on that, conduct a stop and investigate further, okay? Now, that stop can only last for so long. We use the term a reasonable amount of time. However much time it takes me to investigate your involvement in this alleged crime, that's all I need. It can take me 10 minutes. It can take me 25 minutes, okay? There's no limit technically, but we have to be reasonable. I cannot hold you there for an hour. It just wouldn't make sense, okay? So let's say to finish that stop up, we stop the individual, we detain them, we handcuff them. The first thing I need to do is try to either dispel my suspicion or confirm my suspicion, okay? So we walk away from that individual. I have my partner check the back door of the business, okay? Let's say there's no damage. There's no sign of a break-in. There's no burglar tools around, like a crowbar or something to that effect. Let's just simply say nothing's happening that stands out, okay? Well, based on that, I'm not led to believe that this person tried to break in because there's no evidence to say he or she did, okay? So at that point, we will probably release him. It took me every bit of 10 or 15 minutes to dispel my suspicion. Now let's flip that and let's say my partner noticed damage to the back door. We also saw a crowbar next to the back door as well, okay? So based on that, based on the initial factors, based on him being within close proximity of that business, right? A burglar tool close by and damage to a door that he was just close by to, based on that, I am led to believe, right, that this person may have tried to break into this building. Now we reach the level of probable cause. Well, Officer Perry, what is probable cause? Probable cause is defined as facts and circumstances which will lead a reasonable person to believe that a crime has been committed and that a particular person committed said crime, okay? Now, we're not talking about proof beyond a reasonable doubt. Don't get that twisted, okay? That's a totally separate standard of proof, a very high standard of proof. Probable cause is a very low standard of proof, okay? Probable cause simply says this: a crime was committed that I believe, okay? And that this person that I stopped more than likely committed this crime. There is a higher probability that this person committed this crime versus a lower probability, okay? So we will make an arrest at that point. So we just went from a brief detention based on reasonable suspicion to now me believing it, and we've reached the level of probable cause. We would then conduct a custodial arrest, okay? So that's how we talk about that. Let's talk about searching vehicles. Can the police search my vehicle? They can, yes, if they have reached an exception to the warrant requirement rule, okay? So we have case law that has opened up the realm of exceptions to searching vehicles, okay? Carroll v. U.S. is a very important case that I discussed with the recruits a lot, that essentially says that if the police can establish probable cause to believe that there is contraband or evidence in this vehicle, they can conduct a search absent a warrant. That would be deemed a warrantless search. So the same probable cause that I have to conduct this search right now should be enough to go write up an affidavit and get a search warrant from a judge, okay? So that's an exception to that rule. So in most instances, it is not easy to establish probable cause for a search, okay? Sometimes police ask for what's called consent. Consent is another exception to the warrant requirement, okay? but consent has to be given voluntarily. Okay? So just kind of keep that in mind. They can search, but only with certain exceptions. Okay? Lastly, can the police come into my home? Yes, they can if invited inside. Okay, now there are exceptions to that rule too. In most instances, the courts would strongly prefer that you get a search warrant. Okay, they would strongly prefer that you get a search warrant. But if you don't, that's okay if you can establish a certain exception to go inside that house. Okay, most situations the police are invited in. If we observe certain contraband in plain sight, we can take action if we need to. Okay, we can ask for consent to come in if necessary. But when in doubt, if you believe that there's contraband or evidence in this home, always get a search warrant. We have a question.
Yes, Reverend Gray.
Yes, sir.
And I'm sure you'll get to it, and I appreciate this. From what you've said to us as relates to particularly the First Amendment, Fourth Amendment, I'm sorry. People stop. How, because we are a detention facility oversight board, where, if anywhere, would any of this apply to correctional officers and or detainees? Because we're talking about rights. So, and maybe that's going to be somewhere, down the line, but just to kind of throw that out there. And I'm going to go back on mute now.
No, it's okay. So we will touch on that, yes, but I'll bring it up now. So when people are arrested, they completely lose their right to privacy. Okay, so we search criminals on the. I don't want to call them criminals. We search offenders that commit crimes that we arrest for probable cause on the street. When they are in institutions like the station's holdover, the Justice Center, they have little to no rights in terms of privacy. They can be searched essentially at any given moment. I would imagine first that the facility must establish certain rules to put in place to say, hey, listen, under these set of circumstances, we can conduct searches of cells, we can conduct searches of inmates, etc. Okay. Now keep in mind also that correctional institutions conduct searches that police won't conduct routinely on the street, such as strip searches or more invasive searches of inmates. Okay. And that would be for a plethora of reasons, obviously, to prevent contraband from coming inside, and of course, the exchange of weapons. Okay. So they conduct more in-depth searches inside of any institution that is designed to confine inmates. So yes, they would completely lose their right to privacy.
Are these facilities obligated to say to someone, say the police bring somebody to the detention center, this person is going to be booked in, they're going to be a resident of the detention center for whatever time they are. Is the correctional institution obligated by law in any way to let these detainees know, based upon the fact that you are a resident of our facility, you now what's the word I'm looking for? Revoke all your rights. So I don't know if that's a vague question. I don't know if it's an appropriate question. But if our job is, as an oversight board, is to make sure that people's rights are not violated, at what point do detainees know they have no rights? Or maybe not no rights is a stretch, but their rights are limited. And then I'll really go on mute now.
So to my knowledge, and I'm no attorney, but to my knowledge, there is no document or any information I need to provide to an inmate to say, hey, listen, at any moment you are subject to be searched. They don't sign anything, to my knowledge. Again, I'm not an attorney. I can't specifically speak to that, but to my knowledge, there's nothing to sign, no waiver, no notice, a sign on a wall that says you are subject to be searched at any moment. When we arrest people, we immediately search them. Okay, that we call it a search incident to arrest. So incident to this person's arrest, we would then conduct a full search of this person, not only to retrieve their personal property so we can store it and log it, but of course, any contraband that we find on their person is subject to be seized, and that person can be additionally charged with whatever we find. So even when they are transferred to the Justice Center, there's no notice that I'm aware of that they're given to say, hey, listen, you're subject to be searched at any moment by staff.
All right. Thank you very much.
Absolutely. We have another question?
No, just kind of a point to be made. Having worked there at the Justice Center, yeah, you can be searched at any time for any reason or no reason. Your cell can be searched for any reason or no reason. Probably the first documentation you would have of that is once you got housed and get your orientation in an inmate handbook. But the majority of people know the score, but some people may not. But yeah, that's definitely, you can be searched at any time.
Interesting. So I teach at Lincoln University at Harris Stowe, and I learned from one of the correctional facility members that even staff is searched. So
yeah.
Correctional officers who come in and search. So that was news to me.
Yeah.
I didn't even know that.
Yeah. When you enter the secure perimeter, you are at least pat searched.
Interesting. So see, that's something that I learned. Very interesting. So that's how we talk about in terms of the Fourth Amendment. When we talk about unreasonable stops, seizures, searches, etc. Let's kind of dive into the Fifth Amendment, okay? So the most important aspect of the Fifth Amendment we talk about in class is self-incrimination, okay? Are you legally compelled to speak to the police under any circumstances? The answer to that question is no, okay? At any moment, the police suspect you of a crime, they speak to you, they can simply walk up to you and ask you, how are the Cardinals doing? You are not obligated to speak to them, okay? So if the police accuse you of a crime and they ask you a guilt-seeking question and you are in custody, that is considered a custodial interrogation. You are not obligated to speak to them, okay? So I provide the recruits with a Miranda equation in class in order to understand when Miranda is required and when it is not required, okay? So the equation is this: in custody plus interrogation equals Miranda. Let's break that algebraic situation down, right? In custody, what does it mean to be in custody? In custody means that your right to freely move around has been taken away from you in some significant manner, whether that be a brief detention, which means you're not allowed to leave initially, or a custodial arrest, okay? So your freedom of movement or your liberty to move around has been denied in some significant way by the police. That was in custody, okay? An interrogation means that I ask guilt-seeking questions or questions that are designed to elicit an incriminating response. I make statements that is designed to elicit an incriminating response, or I take some action that is designed to elicit an incriminating response, okay? An interrogation doesn't always have to be in the form of questioning. A lot of people get that confused, and that's a huge misconception, but it doesn't, okay? I can simply make a statement that is designed for you to just tell me what I need for you to tell me, right? Hey, listen, if you don't talk to me, we may arrest your mother, or we may call DFS for your children. That would probably pressure somebody into speaking to the police. If I exhibit a certain piece of evidence to a person with hopes that they speak up and tell me what I need to know, that is an action that I took that is designed for them to respond to me in a guilty manner. And obviously, if I ask somebody a question, hey, listen, did you rob the 7-Eleven? Obviously, there's a guilt-seeking question, okay? So, am I obligated to talk to the police? Absolutely not, okay? At no moment is anybody ever obligated to talk to the police, okay? And anybody who has had an interaction with the police should know, okay? They should also know that anything that you do say, we're probably going to use against you, okay? There's nothing that you can say to the police that will help you. Even if you tell us something innocent that you did, it probably won't help you, okay? So I'm pretty sure when you investigate people at the Justice Center, they may provide complaints to you to say, well, the police pressured me into saying this. The police did this to me, okay? That same right would travel with them even as they're incarcerated. They maintain that same right to remain silent, okay? We talked about Miranda. Well, we didn't talk about Miranda rights, but Arizona v. Miranda, right? I mean, Miranda rights, okay? Very important. We understand that. You have the right to remain silent, Fifth Amendment. You have the right to an attorney, Sixth Amendment, okay? And we'll dive into that in a minute. Very important. Miranda v. Arizona, okay? When are the police required to inform me of my Miranda rights? We talked about that equation, right? So if that person is in custody, we've denied them of their freedom to move around in some significant way, and we insist on asking, making a statement, or taking an action that is designed to elicit an incriminating response, we must read that person Miranda. From our Miranda card. We have a department Miranda card that we read verbatim from. Excuse me, at least we're supposed to. I can't speak to what they're doing, but we're supposed to. Okay, the Sixth Amendment is real simple, right? Anybody who is accused of a crime has the right to an attorney. Now, when you are arrested, you won't have access to an attorney unless you have retained a private attorney, which is not cheap, okay? If you want an attorney or legal representation in the form of a public defender, you technically are not provided one until you're formally charged. Formally charged means that the circuit attorney's office has issued a case on you, and we are taking the process forward, okay? But despite how poor you are, even if you're rich, okay, and you want to be provided with a free attorney, we provide that to you, okay? What may happen if I do not have an attorney? Well, in most situations, if people elect not to have an attorney, they're probably going to say something guilty, which is going to hurt them later, okay? Uncounseled offenders typically say something guilty or say something that they shouldn't say, okay? Most defense attorneys will pretty much preach to anybody that they represent, please, please, please never talk to the police. Don't even tell the police what you had for lunch, okay? Because they'll find some way to take a meal from Chick-fil-A and make you seem guilty and that you were involved in a burglary, okay? So any attorney will tell somebody that, all right? Just something to think about. Okay, we kind of discussed reasonable suspicion. I won't dive into that much. Just keep in mind, Terry v. Ohio is the case that created reasonable suspicion. And again, it's the legal justification necessary to conduct a brief detention of a person, okay? We talked about probable cause. What is it? This is the justification we need to legally take away somebody's freedom and arrest them, okay? Without establishing that first, we cannot legally take away anybody's freedom, okay? Now, that's essentially all you need to know on the constitutional side, okay? That will help you going forward. We'll kind of dive into the Missouri Criminal Code real quick. I'll be brief. I won't take long because I want to get to the prisoner's rights and I want to tie you up too long. Real quick, in the class, I teach the recruits from the Criminal Code Handbook. These are all the criminal statutes that the state thinks are important for police, okay? These books are technically specifically designed for law enforcement, but anybody can buy a copy. I highly suggest you buy a copy. You may or may not need it for your function, but I mean, it's just a great reference to have, okay? In the event that somebody complains about a charge or something like that. So it's broken down into 21 chapters. It's split into half, general provisions and specific offenses, okay? It also has some information about civil process as well. So this is just an example of a burglary statute. And again, if we're thinking about inmates and people that are incarcerated, okay, we need to kind of understand the charges that come about for police, okay? So when people are charged with a crime, first the police have to reach a certain burden, okay? So as you look at this, the burden that we have to reach with any criminal statute are the elements of that crime, okay? So when I explain to the recruits how to understand the elements of a crime, I want them to think about the ingredients to a recipe, okay? You could probably break it down like it's a cake. The elements of the crime are the ingredients to that cake. If you are missing an ingredient, you can't make the cake, okay? You can't make that charge. But if you have each ingredient, which are each element to that crime, then you can charge appropriately, okay? Now, as we go through the criminal process, people are arrested and charged. We have to see if they can be formally charged by the circuit attorney's office, okay? They can either do one of three things. They can either issue a case, which means we're going to go forward in the process. They can refuse a case, which means that we're going to stop, the buck stops there, or they're going to TUA it, which also stands for taking a case under advisement, okay? They may require more information. They say, hey, listen, go take care of this, bring this back to us. We'll reapply and then we'll make a decision from there. Okay. So some of the important things that I want to talk about to the recruits, and I also implore to the Citizens Academy or whoever I give this presentation to, is that the most important aspect of police work is report writing. Okay. A lot of policemen take this skill for granted, but it is by far the most important. Okay. Without a good police report, you cannot get a good prosecution. Okay. You probably won't be a successful policeman if you cannot articulate a crime or an incident chronologically and detailed in a police report. Okay. Warrant dispositions, we just talked about it. Okay. Issuing cases, refusing cases. We know people are being arrested every day. Okay. I'm pretty sure these are things that you will probably keep track of at some point, because these people are going to the Justice Center and one of a few things are happening. Either they're being released on their own recognizance, they're being held without bail, they're giving tracking monitors, etc. Okay. I'm pretty sure these are things that you guys may think, look into. Maybe, I'm not exactly sure. Grand jury and prelims, that's just kind of working its way through the criminal process. That's also a way that we establish probable cause for the second time by an objective body of the court. Okay, grand jury is a private setting, just an attorney, a prosecutor, the jury, and of course any witness that was involved. No defendant, no defense attorney. Prelims are a little different. There's a judge there, no jury, but there's a prosecutor, defendant, defense attorney, and it's like a mini trial. And at that point, the prosecutor has to establish, well, the judge will establish probable cause, will determine if probable cause exists in that case to carry it over to the next step in the criminal process. Okay. Plea bargaining is a big deal for the state. It saves them a lot of money, a lot of time, because criminal prosecutions can be very expensive and can be taxing in terms of time. So we try to prevent that from happening. The last time I spoke to somebody, they stated that approximately 85% of the cases that come through the state are pled. Okay. However, St. Louis takes the most cases to trial than every judicial circuit in the region. So that's also something to think about, which is important. It's the right to do so. Okay. We won't really dive into police involved shootings. That's not important. We won't even discuss that. Any questions about this portion? I hope I didn't go too fast.
No, you're doing great.
Okay, so real quick, we'll transition to the next thing that we'll discuss, which is prisoners' rights. So I'll zip through that. I won't take too much time. I'll just kind of hit the most important spots, and then we'll move on from there. Give me a couple seconds. Let me find it. I've drafted all of these presentations for the recruits. There's also some videos built in. We won't waste our time with the videos. We'll just kind of touch the highlights and then we'll move from there. So this is section 206, prisoners' rights and privileges. The first thing we discuss is what a right is, right? So rights are guaranteed by the Constitution. Some can be stripped based on some legal process. Some are just permanent. Some stay, okay? Now, those can only be stripped based on due process, right? So the due process clause was built not only into the Fifth Amendment, but it was attached to each individual state in the 14th Amendment, which also talked about equal protection under the law, due process, and citizenship clause, etc. Okay? Now, a privilege is different, okay? Privileges can be given and taken away. They are not guaranteed. Typically, though, in order to take away or strip an inmate or prisoner of their privilege or privileges is to have some type of process in place, okay? So one privilege may be conjugal visits, okay? If an inmate has this privilege, but they violate some rule inside the institution should have some rule or administrative process in place in order to strip that privilege from that inmate, okay? So again, these can be given and taken away, but they are essentially governed by the facility themselves, okay? It is solely up to them what privileges they provide and what they don't provide, okay? That just talks about how prison is a consequence to committing certain crimes. We also talk about the Eighth Amendment, okay? Cruel and unusual punishment, excessive bail, etc. We cannot just treat inmates inhumanely. They are humans, okay? We have to treat them like humans. We understand that, hey, listen, there's a criminal process involved. but this person is technically presumed innocent until proven guilty. Okay, a lot of us tend to forget that sometimes. That hey, listen, yes, they have been arrested. We understand that, but there is a process to this. Let's make sure we respect that process and we don't mistreat them while they're in our institution. Okay, which can be problematic for not just the institution, but of course that inmate's family. It affects us all. Okay. That's not important. This just kind of talks about how privileges are controlled by the facility, but rights are not, they can't be stripped by the facility depending on what the right is. Okay. And we'll kind of talk about that in just a minute. What rights? So some of the rights that they maintain: freedom of religion. Okay. They maintain their freedom of speech, which is limited. I'm pretty sure the facility limits the type of speech that they can make. Of course, they can't speak to members of the media, obviously. But with them amongst themselves, they can freely speak as they wish to. When it comes to unreasonable searches and seizures, again, the facility controls that. Okay, so at any moment the facility chooses to search an individual, they can probably do that. Okay. Of course, the right to be a witness against themselves, which is self-incrimination, built into the Fifth Amendment. Okay, they maintain that right throughout the whole process. So even if they're charged or accused of a crime, even while in the institution, they still have the right to remain silent. Okay. Now, when it comes to internal matters, let me ask you guys this question. If there's an issue inside of the institution, of course, if there's a complaint filed, etc., we, with the police department, we have internal affairs. Is there an internal affairs within the Department of Correction? I'm just curious. That's something that I was curious about. I'm not sure.
James,
Yes.
Can you respond to that?
Yes, there is. There's an investigative group of internal affairs officers, and yeah, we have a lot more access to video footage and audio and stuff like that. But yeah, we do have a investigative body within DOC.
Interesting. Okay, thank you for that. I appreciate that. So this just kind of talks about the right to be informed. If you're accused of a crime, of course, you have the right to an attorney at any moment. If you have access to bail and you're granted bail, you have that. And it can't be excessive, again, which is built into that Sixth Amendment. We don't treat people cruel and unusual. Obviously, that's a violation of the Constitution in itself, the Bill of Rights. Okay, we cannot mistreat people. They have equal protection, just like everyone in the facility. Okay, that does not go away. We still have to process. We have to follow that due process of law. Okay, we cannot veer away from that due process. Okay. Of course, the right to an attorney. If we need to separate inmates, we can do that. Okay. If there's a fear that somebody may be assaulted, we can separate that person. Okay. If there's fear of even sexual assault, we can separate that person if we need to. Okay. And of course, if somebody requires medical treatment, medicine, we have to provide that to them. Okay. It is what it is. We cannot deny them of that.
Wait a minute. Can you go back and say that again? Wait, can you go back and say that again? That last one.
Sure.
I'm really being facetious, but I did want you. So, and as you're saying, these are general. Are these general rights? Are these specific rights? Are these rights that is documented somewhere that says these rights are standard?
Yes, this is built into the Constitution. Like, this is just standard protection of individuals, equal across the board. I mean, think about it. If that person is incarcerated in our institution, we are responsible for them. How would they have access to medicine if they contract some disease or some virus? We have to treat them. If they break a limb, if they suffer from an aneurysm, we have to provide emergency services to that person to get them to the hospital. I mean, those are just basic human rights.
No, I appreciate it. And I appreciate the fact, Officer, because I don't know your rank, but Officer Perry, that the way in which you're making the presentation, you're not cutting any corners. You're not being politically correct. You're saying, this is what it is. Now, they're not going to let you do any more presentations, by the way. So anyway, go ahead.
Maybe not. Maybe not. I'll do my best. I'm just doing my best. That's all. Okay. So I'm sorry. Let me go back. Oops. Back. So these are just some videos. This portion is not important. We kind of talked about that self-incrimination, due process, the right to bail, etc. We'll kind of zip through that. That's not important. Again, we kind of discussed privileges, which are offered by the facility but can be taken away, okay, based on whatever process the facility puts in place. But they have to be provided equally. We cannot differentiate inmate to inmate, right? We can't mistreat him and not provide him with a certain privilege just because we don't like him. We have to provide him with the same privilege unless he violates any laws, I mean, not laws, but any rules put in place by the facility that we can document, okay? So we have to offer that to everyone. We cannot treat anybody different. Again, those privileges are controlled by the facility itself. This just kind of talks about detention facilities versus holdovers. We'll kind of get to the definition of that in just a minute. Certain privileges include visitation, telephone usage, recreation. These are things that can be stripped, okay? If I understand correctly, they have like iPads, television at the Justice Center, things like that. Though I would imagine those are privileges that can be taken away, okay? Commissary access to the library, education on any legal understanding that they need. Again, these are all kind of privileges that are provided but can be taken away, okay? Work assignments, etc. So again, there has to be a process, okay? To essentially provide a privilege, which is designed by the facility. There has to be a process in terms of stripping it away, right? Give them a copy of the rules, make sure they acknowledge the rules, and that they understand what consequence there is if they violate said rule, okay? And of course, if there's an issue in terms of language, we have to provide an interpreter to make sure they understand as well. The grievance process, real simple, right? We have to provide a grievance process for them inside the facility. If there's an issue, we have to provide an outlet to them so that they can give whatever grievance they may have, right? Which is important because, hey, they may want to note something that is happening within the facility that is not, that somebody may not be transparent about. And that's okay, okay? We want to be open about things. When it comes to liability, do not act in a punitive fashion. Of course, we don't want to seek to punish. It's not designed for that. We want to document everything that we need to. This case is not important. It's important for the recruits. We'll just kind of zip through this. That's not important. This case is not important. This does talk about deliberate indifference, okay, which is important. Because if things happen under the color of law, by a correctional officer, by a police officer, anybody who was acting in a discretionary fashion under the color of law, if we have violated any civil rights of that person, they would then file a lawsuit. Okay, Section 1983, federally, which would allow people to file lawsuits for civil rights violations for government actors who act against them. Okay, and again, this applies to correctional officers as well. Okay. Okay, real quick, we're at the very end. This just kind of gives some insight on our special orders for the police department, holdovers at each area station, North, Central, South. We all have them. They're only designed to be temporary, okay? People are really not allowed to stay in those within a period of 8 hours. We try to get them to the Justice Center and transfer them down within hours, okay? 1 or 2 hours. We're not trying to hold on to them, okay? Every person that is processed at the station will go down to the Justice Center unless it is a case, from what I understand with our new SureProtect system, it is a pod case, okay? They can be fingerprinted and released from the station, or if it's an original city ordinance violation with no other pending charges, they can be released from the area stations. That process hasn't gone live yet, but it is in the coming future, okay? Just some more things. Juveniles are never detained in a holdover at the area station. If that happens, that is a clear violation of policy, okay? Any certified juveniles go straight to the Justice Center, but always call the Juvenile Detention Center to get advice all the time, okay? The police officer has the primary duty of taking care of their inmate and processing paperwork, okay? At any moment. That person is our responsibility until they get down to the Justice Center, okay? Uncooperative prisoners are placed in their own cell. They're not placed in a cell with anyone else, okay, because we don't want them to hurt anybody. Same-sex prisoners are held together, okay, males, males, females, females. If it is a transgender male, transgender woman, we will place them in a cell alone, only because there is too too much room for liability. They can be assaulted too easily. We want to prevent that from happening. We just totally separate them. And it is not designed to be punitive. It is designed to keep them safe. Okay. Prisoners are booked at if they're booked at the area stations, they are directly taken down if they're pregnant, they have a mobility issue, or they're disabled. Okay. We don't let them stay at the area station. We immediately after being processed, they go straight to the Justice Center. Okay. Of course, we want to check the cell before we place people in it. When we take people out, we want to check for contraband, evidence, etc. Anytime we do that, we want to check when they're before they're placed in and when we remove. Okay. We talked about custodial searches. This is a thorough search. This is the most common search that we conduct as police. I would imagine this is the most common search that is conducted by correctional officers at the Justice Center. Okay. If it's some type of strip situation, I'm pretty sure they can articulate why to do so. Okay. All prisoners will be subject to a thorough custodial search. That's just standard and by the same sex officer. Okay, so male, male, female, female. It is totally inappropriate for either to do the either. Okay, the only situation that is unique is that if it is a transgender woman or a transgender man, they technically by policy get the choice. So they get to decide, hey, I'm more comfortable with a male officer or I'm more comfortable with a female officer. Okay. And if needed, we'll remove the items from a property that we collect, etc. Okay. Again, strip searches, if necessary, they have to remove garments. Again, this is not common for police to do. I'm not sure what happens at the Justice Center, but for police work, it's really not common. Of course, body cavity searches, we almost never do. If somebody has placed something in an area of the body that we cannot remove, of course, they have to go to a hospital, but we need to get search warrants for that because that is very invasive to do for a person because they have a huge expectation of privacy within their person. Okay. All right. That's it for me. Does anyone have any questions at all?
I have one.
Sure.
The training that you said you do training at the academy.
I do, yes.
So you're trained, but is your training limited to police or what we just saw? Is this information presented to COs and other staff that work within detention?
No, this is strictly post objectives that are provided to us by the state for police, just police that I know of. I'm not sure what kind of training they get, but I don't teach this to correctional officers, no.
Okay, I just want to say you did an excellent job, young man. I just want to say you did an excellent job. Yes, I think Pam, is that you?
The first day of training that corrections requires, I was going to say to Officer Perry that I was really pleased that the corrections trainer said the same things he's saying as far as prisoners and their rights and how it operates. And it's very similar training targeted to the corrections officers. Okay. So yeah, they're on the same page. It was really good. Thank you.
Fantastic.
Any other board members have any questions? Any other board members? I was almost without seeing any hands. I almost asked you to go ahead and show us the video so we could get to those 40 hours, but I guess I'll leave that alone. Because I had some popcorn back there in the back, so I figured if we did the videos, we might be able to squeeze it another half hour, just in case. But no, in all honesty, thank you. What is your rank? Could you tell me?
Yeah, sure. So I'm a police officer right now at the police academy. So I'm in a police officer that's ranked, but I'm a general instructor at the academy.
All right. Well, Instructor Perry, you did an excellent job. The presentation was very thoughtful, very provoking. I did get a text message. I won't say who it's from. They asked me if I could get you to become a commissioner for corrections somewhere. But anyway, don't answer that. Don't answer that. Don't answer that,
Okay.
Officer Perry. Don't answer that. I'm just telling you how board members think around here.
Yes, sir.
Anyway, if there are no questions, again, thank you very much. This was extremely helpful.
Absolutely. Anytime.
And so if there are no questions, board members, is there a motion then to adjourn?
I would like to
motion we
thank
adjourn.
Officer Perry and second that motion to adjourn.
There you go, James. There you go. There you go. That's my guy. That's my guy. All right. I don't even know who moved it. I know James second. Who moved? Who made the
Tom.
motion?
I did.
Okay. It's been probably moved by Tom, seconded by James, that we adjourn with our wholehearted thanks to Officer Perry for a great presentation. All in favor of the motion to adjourn, say aye.
Aye.
Bye.
Contrary minded, nay. Motion carries. Thank you all very much. We will talk, I'm sure, this week, but we will see you next Monday for our next training.
Have a great night,
Have a great
everybody.
night, everybody. Everybody be
Bye.
safe.